Listen, folks, I know there's a history here. I'd like to get this hearing in today. You know, everybody needs to just focus on the relevant facts, okay? I know there's a history here.
Are you talking up by Sunset Mart? Up the hill by the gas station?
Yeah.
Okay. Why did you...
Welcome to the Transparency Saturday afternoon.
Who's responsible here?
I'm fucking responsible
Whose house
here.
is this?
Let's go. Let's fucking go. Think about our rights.
Okay, drive careful, okay?
Come on in. Come on in.
This is what the other group had that ran away.
Oh, really? You just did shit? Awesome.
Yeah, those ones kept walking in the car. And the other one.
It's truly for the win.
This live is dedicated to Miss Annie Potts. She's been waiting for this for a long time, so that's my shout out. That I was given to. So there was 2 different discs. Okay, they all knew about it. 2 cell phones.
Talk about the alcohol stuff, okay?
Okay, yeah.
But this is the second noise complaint we've had here tonight within 2 hours.
How are you?
Good, how are you?
Good. Is this your place?
Yeah.
Perfect. You know why we're here?
I see noise.
Noise, yeah.
Yeah.
Big speaker right there.
Yeah.
Nothing against having a party. Once neighbors start calling in, then we have an issue.
Like brains, and like if you need a lot of brains, you're gonna be in trouble.
What's up, guys? Hello, welcome to Truth and Transparency. Happy that you guys could all join me. Today we do have a goal. We're going to try to reach over the next course of 30, 60 days. I'm going to be spending a lot of time in Idaho. I told you guys this was coming. We said this was coming, which was a Frank's, but more importantly, in my opinion, it's what was going to be filed, what we're going to be seeing. Is this going to be Bush League? Is this going to be, oh, this is just another defense attorney who's filing papers because they have to do this, they just have to go through the motions. And we brought it to you guys here 2 years ago. I said, the Moscow Police Department and anybody involved in this case, this day is coming. This day is coming because a lot of fuckerage went down. And yesterday was the day that we, the public, got to hear and see most of it, 90%, I would say. Thank you so much. 90%, I would say. They had to keep some stuff under seal, and we're going to talk about why. But yesterday was the day. So let me go ahead and pull up. I got Hector here. Hector will be my assistant. So welcome, Hector. So I've already gone through everything, highlighted the points that we're going to talk about, but there's 15 different filings that dropped yesterday in the e-file. Moderators, shout out to you guys. Love you guys. I will be running a stream on January 23rd, 2025. I'll be running a live stream. I will be streaming live the hearing in Boise for this Frank's and suppression hearing, which is going to go down big discovery day. It could be, it's January 23rd. I will be in Boise, Idaho for that. I will be in that courtroom. So I will be streaming it. You guys can all watch it here live. I'm going to try to get a front row seat so you guys can. But we're allowed to believe have our cell phones. I'm going to work towards getting my media pass here because I want to be able to have my laptop up if they're offering the media section. And I want to be able to tweet live from it. But if there's anything that's going to go on that happens, maybe if the cameras aren't on, this could be a sensitive hearing. And so maybe they will be turning off the cameras at any point, but maybe they'll be allowing those that are there to see stuff that potentially the entire public doesn't have a chance to see. And this is going to have a lot to do with the IGG. Okay. We're going to get into all that. So I want to first talk about number one, the defendant's motion for leave. Okay. This was filed. This has nothing to do with, I saw messages out there talking about, oh yeah, but Hippler already denied stuff. We're going to get to what Hippler did, but the defendant's motion for leave. So what you guys can see here is this is a fatty stack. Okay. This is all the papers that were filed in connection with anything that has to do with suppression, Franks. But we open it up with the defendant's motion for leave. So I'm going to get into it. I'm going to make this screen big and I'm going to bounce back and forth with you guys being able to see me, not being able to see me. But I want Hector to do Hector's job. So this defendant's motion for leave. Now, I personally think Ann Taylor and her team are 100% geniuses. And I'm going to tell you why right off the rip. The reason that I believe Ann Taylor filed this is to set precedent in this case. Then what I mean by that is let's go ahead and see what she's saying in this motion. You know, comes now Bryan C. Kohberger by and through her or his attorneys of record and hereby moves this court for leave from the court's order governing further criminal proceedings and notice of a trial setting because specifically they're saying the discovery motions deadline, which is November 14th, 2024, that's their deadline. Bryan Kohberger's team's deadline. I am going to be hitting up, guys, just also want to say, anybody that's hitting over here, I have this new little timer thing that I do. And so every 15 minutes, I will go and make sure that I hit everybody's super stickers and things like that when I'm doing a live that's me being so focused and getting the information out. So just a heads up there. I will ring the bell too. It's going to be like Mike Tyson, baby, going 8 rounds. Give it up for Mike Tyson, man, who's 58 and can show his assless chaps, man. Did you guys check that out on Netflix? I stayed up to watch Mike Tyson do his thing. You guys know that Paul's from Ohio too. I mean, us Ohio people just fucking rock. All right. Anyways, so this is, if you guys can see there, yep, here we go. The defense counsel and investigators have not had finished a full review of the vast amount of discovery in this case and will continue to do so. Counsel requests that this motion be set for hearing because they want to say that basically we're getting all of this discovery, right? We're trying to go through it. And the only way that we can give reciprocal discovery is by us going through stuff. And if we can't go through things in a timely fashion because you're going to see we don't even fucking have it yet, or we were just given it. So we're going to get to why he denied it here at the end because this was technically filed on the 15th. Okay. So we're going to come back to that at the end here. And I'm going to say why I believe that this was a motion that was filed. It was filed on the eve, okay, of when this due date was. And Hippler had mentioned that he does not want people to wait till the last minute to file things. If you know something, you know something when you know it. File it type of shit. Okay? Well. Fuck it. Before the court is defendant's naked motion for leave. Now, mind you, this is exactly how they were filing stuff around when Judge was around. When they say naked, that means there's nothing to it. Okay. Now, why is it naked? Well, because you want me to put the state on blast. Okay, now I will. It's naked because I don't want to blast the state to the public. Okay. So, but now this is setting precedent. Before the court is defendant's naked motion for leave. Basically bare bones. There was nothing to it. November 13th, in which he's seeking relief from discovery motions deadline of November 14th as set forth in the governing scheduling order, which they did when they had that, conference schedule. It was a status conference update. I think it was October 9th. Defendant asserts his counsel and investigators are still reviewing the vast amount of discovery in this case. See how he put it in quotes? He's using their words. Hippler is. And therefore, he needs additional time to file motions related to discovery. Basically saying we're asking, based on us reading through all the stuff, then therefore we have to type up and we're asking for these supplemental requests, right? Because the state's deadline was September 6th. The last time that the state could get the defense here, this is what we're using for trial. This is discovery. If it's not in discovery, you're going to have to try to get it in, and a judge has to approve it after that point. So motions to enlarge a deadline filed on the eve of the deadline are not well taken. Like, why did you wait till the eve, right? The state's discovery deadline was September 6th. And we're going to talk about this. So that means, and that's why the state, there's been requests that have been after that date. But the state, their deadline to get stuff over to the defense, September 6th. So it's like, why are you asking for this deadline to be extended if the state got everything to you September 6th? And here it's like, well, that's the thing, is the state hasn't gotten us everything. Okay. So we weren't trying to come in here and have you admonish the state. We're trying to ask you to give us more time on this November 14th deadline, right? Because why? Because Anne's not a fucking idiot. This is setting precedent. Okay. This is like, down the road, the state won't be able to do this, right? Which is file a motion on the eve before it's due requesting something. We need more time, right? Ann Taylor just made it so, if you want my opinion, she just made it so that you just set precedent here. You just went ahead and denied this naked motion, because I'm just blatantly saying to have more time because we're going through this vast discovery. Well, you asked me on the night before, and you're not giving. Then he says right here, Hippler says, motions to enlarge a deadline filed on the eve of the deadline are not well taken. The state's discovery deadline was September 6th. Defendant could have ascertained far sooner to let us know that there would be, hey, we need more time. I thought she did that in person. I thought she made that, that point in person, but it's all good. You know why? Precedent right here. Whether the discovery motion deadline would pose a difficulty and brought in the court's to the court's attention. We didn't think that it would be an issue, but we're filing these motions for supplemental requests, and Homie Nuts on November 10th from the state filed and said that he is basically met. He wrote all the dates that they've ever turned over discovery, and the last day that he did it, imagine that, September the 6th, the last day. Okay. But there's been so many other supplemental requests after September 6th. But on November 10th, the state says we're in compliance over here. Well, we're about to find out. No, you aren't. So, Hippler says, defendant has not demonstrated with his filing, because they just wanted to keep it brief. Hey, boom, boom, boom. It was naked. We want you to lay it all out there. And then probably Ann's team's like, oh, hell no. Okay. We're going to lay it all out there. That's going to, the public's going to find out a lot of fuckery going on, but sounds good. But the defendant has not demonstrated with his filing good cause to extend this deadline. He has not set forth what efforts have been made to receive the discovery or review it or whatever. And I'm over here like, are you kidding me? Are you reading the docket? What are you talking about? The defense is putting in supplemental request after supplemental request. That's our efforts. It's documented in the docket, which is the court record. So I completely disagree, but this is setting precedent. Because who has a hard time following the rules here? Who's had a hard time for 2 years following the rules? So this is a naked motion. You didn't explain why you needed the lengths you've gone through and why you need this extra time. Okay? So why it has not been reviewed or how long it will take to complete such review. Consequently, the motion is denied. All right, sounds great. And you could be like, Lana, why does that sound great? You guys, it sounds great because you're not going to be able to just file a piece of paper, okay, on the eve of something, right? And it have bare bones, nothing to it, and then a judge is just going to say, yep, you get this extra time. Do you think Ann Taylor was doing it for that? Or do you think that maybe Ann Taylor, okay, filed that motion to set some precedent in this case? Because Ann Taylor wants to be 5 steps ahead. And I want to set some precedent in this case. Judge Hippler responded from a motion that was filed with an order like that. Lickety split. And I'm over here like, holy shit, this is great. We're not dealing with a Delphi bullshit where Judge Gall is just hanging on to fucking motions, not saying shit about shit. Okay. Hippler sees it, speaks on it, files it, order. 1 day later. Now, let's talk. What is a Franks? It's just a name. It is a name, though, guys, for if you have naughty police officers. Lana, what do you mean? Well, comes now, Bryan C. Kohberger buying through his attorneys. We're going to move this court to conduct a Franks hearing. Why? Well, because this motion is made pursuant to the 4th Amendment of the United States Constitution. And we got some articles of the Idaho Constitution. And we're going to go ahead and cite Franks v. Delaware. There's other cases that we're going to talk about. But Ann Taylor talked with the state here because we have a proffer, which is a proffer. And exhibits are filed with this, but it's under seal. Okay, so this is what we're seeing, but we don't get to see this proffer, and we don't get to see the exhibits that are filed. Okay, and it was filed like when we got this in our e-filings. So did the state. And then now the judge, because he's kind of far away, they got to hand it to him. He's going to get it on the 18th. But it's in accordance with the state verse. Hold on. Let me move my little. There you go. With state verse Fisher, and the parties stipulate. That means they agree. When you see the word stipulate, whoopsies, down here. There we go. So when the parties say that they stipulate, that they're agreeing. So the parties stipulate to this being sealed, okay, and that is the sealing of the proffer and the exhibits. That means Ann Taylor, just so you guys know, if you guys would have read any of this yet, this Franks that was filed is at least over 500 pages. A lot of exhibits to show, because you're like walking the judge through all of the fuckerage that went on. And it's when the police are lying. You have a Franks hearing when you can prove that the police lied in a probable, like in an affidavit to obtain, to say that, hey, we have probable cause to do X, Y, and Z. If the police lied to get a judge to sign off on a search warrant, okay, this is why you have a Franks. So here, the state stipulated to, here we go, we're going to seal all of this stuff. And it's under seal. So we don't get to see anything about this, but we do get a lot of clues throughout the filings. So the under seal proffer and exhibits are being provided to opposing counsel and the court staff, like e-filing, but we have to give you everything in person. Otherwise, there's no way that we could do that. So that's just what that means. Like the judge and they're getting theirs in person on the 18th. So that's and if you guys know the Delphi case, it's when you're showing X, Y, and Z. And the big thing here is we're going to talk about is obviously the probable cause for the arrest of Bryan Kohberger. And we're going to get into that. So, like I said, first thing was we talked about that motion for leave. Now we have a Franks hearing, and now we're going to get into the motions to suppress. So motion to suppress, and the first and foremost most important thing here is genetic info. And there's keywords that I want us to focus on with the filing. So here it is, the motion to suppress genetic information. Make this bigger. Really quick, shout out to, let's see, number 7, 1 through 7. New member, welcome, Grady. Bogado, is that right? Patty, $10 super sticker. Woo, Patty, baby. William, love it. You've been here for a long time, William. We got our Franks. Told you guys it was coming before the holidays. Donna M, baby, love your face. Those cat eyes. Meow. Yes, Idaho4. Gonna be a lot of that. Donna made 5 people in chat go green. She gifted 5 memberships. And let's see. We got, is that Bree Silva? Woo, welcome, super sticker. Carson, let's reach our target goal, bitch. Love her. She's a sweetheart. DMC, aka Lady Di. Hit that thumbs up and let's get landed to our goal. Let's show YouTube and the TNT family it's the best. It is kind of cool here. I will say that. It is kind of cool here. So here we go. Comes now Bryan C. Kohberger right here. And moves to suppress all evidence illegally. Key word there, guys, is illegally. Okay? Illegally gathered by law enforcement using his genetic information. When I saw that, I said, I got to make sure my viewers know this. Using his genetic information. Now, this made me think a little bit because I don't know if you guys know. You guys have been hanging out for a minute. I did have a pretty cool IgG specialist on the show at one point. Also, then I wanted to learn a lot more about the process there with the investigative genetic genealogy. So I thought about different ways this could have all ever happened. And something that was interesting right here is that illegally gathered by law enforcement. Okay, so using his genetic information. So think about that. Because I remember the different questions that I wanted to ask about that. And is there any way that, and we'll get to it here when I wrap it all up, but just, so moves to suppress all evidence illegally gathered by law enforcement using his genetic information. This motion is made pursuant to the Fourth Amendment. Okay. Illegal search and seizure. Now, because this was under seal with the IgG stuff, the defense notes that, hey, we are abiding by what judge said. And this motion is being filed under seal pursuant to the Honorable Judge's previous order. Otherwise, they were going to rip it. They were following Judge's order that was still in place because Hippler said anything, so that's why this is filed under seal. All right. So all the arguments that have to go with this one, all right, are under seal. But we get some like little snippets here and there in the other motions. So I kind of figured this was coming with the IgG, obviously. But remember, the defense had to fight tooth and nail to even get, like, again, it went back to, like, how in the fuck did you get to Bryan Kohberger? I said it before the mofo was arrested, because once he was arrested, nobody knew who this kid was. He wasn't part of, like, a friend, nothing. How did you get to Bryan Kohberger? How did we get to a stranger here? Well, according to Indiana, they would never have gone this route because it's so fucking unreliable and it's such shit. But here, Idaho, it's the first thing they did. It's the first thing they did. They didn't investigate the Idaho4 case. There was no investigation. They were at the gathering of information stage of this investigation. Gathering of information stage. And then they went. I gotta stay focused. All I have to say is I hope that the Gonzalez family sues the fuck out of people. I hope that all these families sue the fuck out of people. People need to get sued the fuck out of. Let's go. All right. We need to place this this anger, this pissed off, like what the fuck? It needs to be placed upon the right people. And these 15 filings here, I've been right on where I would place my fucking pissed offness. So here we go. First thing, after obviously IgG, just like the Franks, that part's sealed. Amazon. Wait, what, Lana? What does that say? Well, the Amazon account was obtained through a federal grand jury subpoena, basically. And the warrants that were dated April 26th and May 8th of 2023, we want those motherfuckers suppressed. But why, Lana? Everybody out there, the Kohberger family fucking needs to sue too. Everybody out there is saying, oh, this is just a tactic. Every defense attorney does this. And then this is my comments. Did you read the documents? And then it's crickets. How are you speaking on something if you didn't read this? This isn't just like any other case or any other filing. This is straight up nuts. This is straight up either you have to ask yourself, are they cheaters or are they creative? And you guys can decide. You guys can decide if you think that the Moscow Police Department and the FBI and WSU and the Idaho State Police and everybody else who was involved in this case, are they creative? Are they cheaters? And when I say cheaters, those are violators of our rights. What are they? Leanna, what if it was your kid? Wouldn't you say do whatever it takes to get the killer? I would say, well, when you have the right people, based on your training and experience, when you have the right people, you don't need to violate anybody's rights. When you good, you good. Okay? When you good, you good. So here it is. You're like Amazon. Well, let's see what this is all about, right? So I'm going to make this bigger. Amazon. Now comes Bryan C. Kohberger buying through his attorneys of record, submit the following memorandum in support of this motion that was filed for an order suppressing all data found by law enforcement from its search of his Amazon.com account. Now, they're going to feature, we're talking about Franks versus Delaware. Okay. So the motion and documents in support of a Franks versus Delaware hearing are hereby incorporated into this memorandum because that's under seal. So it's letting us know that, hey, everything that's in the Franks is incorporated with this memorandum, but because it's under seal, like obviously we can't write that here. Okay. So the proffer with supporting documentation regarding the Franks are filed under seal. For that reason, they are not here. Okay. But we got some things, we got some issues here. And the first thing is why do you want to suppress something? What are the issues? Okay. If you want to suppress something, you better know what's the problem here. You want me to suppress something? What's the problem? Okay. We have some problems. Here they are. Number one, Mr. Kohberger has a privacy interest in his Amazon.com account information protected by Article 1, Section 17 of the Idaho Constitution and the Fourth Amendment requiring information that requires a warrant. And everyone's going to say now, well, they had a search warrant. They had a search warrant. You must have a valid search warrant. You must have a valid search warrant. Number two here, an issue is the affidavit. So now we're going to get into, this is your probable cause. The A part of the PCA stands for affidavit. So the PCA submitted in support of the application for the issued search warrant. Now, how much time do we spend on this channel? And I was like, we're going to put all these search warrants in order based on the date that they were asked for. And then we're going to put them in order based on the date that they were received. So we can have two different kind of like, this is what we thought was priority. And this is how we receive stuff back. So just what they could be working with on when they would have seen something to possibly come and go with something else. Then we went ahead and looked at all of the actual search warrants based on the dates and if they were clear, who signed them, and what they were asking for. And remember, we noticed a lot of fuckerage. I said, what the hell is going on here? I said, who is asking for a Reddit? Who is asking for a damn Reddit? And then messes up the date kind of, but then holds on to the Reddit and doesn't turn it in for like 10 days. Like, if it was so important to you, why aren't you putting that why aren't you going and serving the search warrant that you just went and got, like you were so eager beaver within 2 weeks of a murder that you were going and getting a search warrant for Reddit, but that it wasn't important to then serve it. I was like, something's off there. And then everybody thought that, hey, all the search warrants that we saw, that's all that existed. Well, that's not true. There were search warrants that weren't uploaded to that the documents in the docket. Their search warrants. In fact, the AT&T #2 search warrant was never uploaded. So, but basically, the PCA submitted to support the application to go get this for the issued search warrant recklessly or intentionally omitted material information. Now, you have to show this. This is the key word here, is material. It has to be material information. Otherwise, like you're going to get like, fuck you. It's never going to work. Like, you can write that all day, but it has to be material. Otherwise, the issue is not going to be an issue. So, and then number 3, the affidavit. So the PCA submitted in support of the application for the issued search warrant included information that must be excised, which means removed. Clip, nuts, gone. Okay. All information in the affidavit was gathered because of law enforcement's unconstitutional use of IGG. Remember how everybody said, we didn't use IGG to do any of this stuff. We didn't use IGG to do any of this stuff. I was like, y'all are bullshitting. Because without you don't have any, how in the world are you getting probable cause to do any of this shit? Where's this probable cause? So here we are. So this warrant included information that must be excised. It's because all information in the affidavit was gathered because of law enforcement's unconstitutional use of investigative genetic genealogy. And thus, nothing in the warrant should remain. Do you guys remember when we were looking at the PCA back in the day? And it seemed like it was so choppy, like it was cut, copy, paste type shit. Remember I was telling you guys about that? I was like, this is so like this is being, some of the shit didn't even flow to me. Okay. And they talk about it. They talk about it. Here it comes. They talk about it here. So, and the B, information gathered about Mr. Kohberger via previous invalid warrants must also be ixnayed. So the facts, guys, ready? So remember, this is for the Amazon. So Pennsylvania law enforcement, along with officers from Idaho and the FBI, raided Kohberger's parents' home on December 30th and arrested him. Now, at some point, this is a really big key part here. At some point, an FBI agent subpoenaed Amazon records belonging to Mr. Kohberger's account. And I'm like, wait, they don't even know this right now. When they're writing this up the way they're writing it, an FBI agent at some point subpoenaed Amazon records belonging to Mr. Kohberger's account. And then you see you have the little one, this little footer down here. And so I'm like, okay, let's go check this out. Okay. Ooh, here we go. Grand jury subpoenas issued by the government have been the subject of a motion to compel. Now go back to this whole Hippler, why we're asking for this extra time, right? Okay. Grand jury subpoenas issued by the government have been the subject of a motion to compel. There is an order to compel their production, quote unquote, if available to the state, or at a minimum for the states to provide dates of subpoenas. Order on defendant's 4th and 5th motion to compel June 14, 2024. The state has done neither. The state has done neither. And Taylor playing fucking chess, bitch. Okay. The issues in the memorandum are among the reasons a copy of the subpoenas are necessary, because it is unclear what the subpoena asked for or its scope. What's your scope here? What did you ask for? We don't give a shit what the return was. I don't care what you're saying that you got back from the motherfucker. I want to know what you asked for. Okay? What were you seeking? Okay? I want to know the date that you sought out to get this information and what information you were seeking out. And somehow the state, during an oral discussion, didn't comprehend that. Said, well, why do they need to know that? Now, either you're just playing dumb or you are dumb. Either one, I don't respect. It is unclear what the subpoena asked for or its scope. The subpoena return identifies 2 iCloud accounts. And this is going to get interesting here because it's like, wait. So now we have to go back up. Woo-wee. You could see my little wow here. I was like, wow, reading this shit. So now, this is where we left off, guys. A little footer here. All right. Susan, cheers, baby. 33 months, baby. 33 months. Lana, my Shira. Woo! Hey, Hoffy, how you doing? Fancy seeing you around here. We are working on our second baby over here, little mama. Oh, love to you and your little man. Oh, thank you there. Lori, you're the best. 15 months. Sue. $10 super sticker. Thank you so much. Murky. Woohoo. Let us be the ones finding the needle in the haystack. You like that shit? Wait for that. That's coming up. Give it to those you love while they woo. How up 4 months. Look out. Thank you, guys. Cheers, all of you guys. Now, on both December 30th, 2022 and January 27th, 2023, Amazon responded with records showing Mr. Kohberger's purchases. Now, remember we had a couple talks about like, damn, like what type of shit you're able to get. But look at those dates on December 30th and January 27th. Now, this is where I said, who wrote this? Because they're just, I love it. Perhaps recognizing that subpoenaing Mr. Kohberger's records was a violation of the Idaho Constitution. Because guess what happens? Look at, so on both December 30th and January 27th, 2023, Amazon responded with records showing Mr. Kohberger's purchases. But now you have to ask yourself, right? Because the defense is saying, well, when did this happen? Because the defense is saying at some point, an FBI agent, okay, subpoenaed Amazon. They don't even know this answer yet. The defense doesn't even know when the FBI did this. They can't even say a date. But what they can tell us, okay, because they're playing Clue over there, they're like, well, it's got to be before December 30th, because on both December 30th and January 27th, of the following year there, Amazon responded with records showing Mr. Kohberger's purchases. Okay. Now we all know that he wasn't arrested until December 30th. Okay. So we're waiting to see like when the FBI put in this search warrant, right? Or warrants, whatever. But hang tight. Then you have to ask yourselves, why in the fucking world would Moscow Police Department subpoena the same fucking shit months later, right before the grand jury that they secretly had to have because, woo, we are fucked. We have to go seek a grand jury. We have to get a grand jury to indict because we're about to get blown up if we have a preliminary hearing. Why? Why are we about to get blown up? Because Ann Taylor figured it out. Ann Taylor figured it out. Anna, say it one more time. Here it is. Perhaps recognizing that subpoenaing Mr. Kohberger's records was a violation of the Idaho Constitution, that on April 26th, 2023, Detective Mowry of the Moscow Police Department requested a warrant for the same information that the FBI did and that they already fucking had. They were going to try to bury that shit. Y'all understand this? They were going to try to bury that the FBI already did it. That's what the defense is alluding to. Y'all understand that? If you don't have time to read the papers, stop commenting in the comment section because you sound like a fucking idiot. All right? I can't say you look like an idiot because I have no idea what you look like, but just sound like one. Don't mind my kid in the neighborhood. They're playing outside. By the way, we are 3-0. This morning we had our third basketball game. We were a 6-point underdog. We always joke around, like, who are you going to give the points to? And so, you know, the high school kids, they're the ones that are reffing and keeping score. And we got the little kids, and I'm like, they're like, wait, man, Oriana, you're a 6-point underdog. I was like, I don't want your points. We won. We won without the points. When I was in Delphi, I had a miss, and I don't ever miss. But I did it for Richard Allen and Kathy Allen, the truth. But yeah, so cheers. Cheers to the 8-year-olds out there. When I read this, I about barfed. It said basically the defense is calling out the FBI and the Moscow Police Department because they know they're in cahoots because why would you ever request something when you already have the fucking records? But, it's because, you guys obtained them illegally. So that's why Mowry was a stuttering mess when he had to take the stand. I don't know anything. I don't know. I just got asked to do something the last minute. I don't even know what's going on. Yeah, that's what he sounded like. Ridiculous, but whatever. The warrant, by the way. So here we go. Detective Mowry of the Moscow Police Department requested a warrant for the same information, telling the court that an unnamed FBI special agent had, quote unquote, located requested information. The warrant was amended due to a date error and ultimately issued May 8th. You guys, what was going on in May 8th? Come on, man. That's when the information came out that Bryan Kohberger was indicted, motherfuckers. He was indicted. The affidavit for the warrant was signed by Detective Mowry, Exhibit A, that's sealed. However, most of the information in the warrant was cut and pasted from an affidavit originally bearing the signature of Moscow Police Department Sergeant Blaker. But according to Mowry, now the sworn statement of pain, I'm over here like, wow. I'm over here like, oh my God. You guys are just, and I'm like, dude, I was like, I hate to say this, but go watch my fucking shows. And I called this shit back and I didn't even have any of this shit. Okay. I was like, this is exactly what happened. I was like, this is wild. Touche. Thank you for, thank you, Jay and Mathis for proving that I'm not a fucking moron. I appreciate that. This is insanity. And I was like, guys, I'm sorry, but we're just gonna have to wait for it, but it's gonna come out. The basic facts Mowry used to support the search beyond the arrest warrant facts were very minimal. And I'm like, oh God, let's see what he says. He says, a vague reference that an FBI special agent located an account for Kohberger. Amazon provided order history records regarding customer email Brian Christopher 1994 at gmail.com. How the agent located this was not explained. Like, are you kidding me? How did you do this? How? But you don't think that you have to explain that? How did you get something without a proper warrant? And then here's Mowry using shit that was illegally obtained to then get his warrant. And then all of us are just supposed to be like, you guys, stop. Okay. And I'm like, wait, excuse me? Guys, stop what? Guys, stop what? This is somebody trying to get an A on a paper that just fucking cheated their asses off. Like, what do you mean? This would get you expelled from school. This would get you out of the university. What should it do in this situation? It should get you out of a fucking job. You should be fired for this shit. But here we are, the United States of America is promoting people like this. That's what's happening. It's going to get worse. So investigators know that Amazon holds records for identifying devices the customers used to access their account, all the links, all that type of information, anything that you clicked on, placed in your cart, viewed, and saved. Who or how the investigators know this is not explained. Based on my experience, then they say this stuff. And it's like, based on your experience, how would you know that? Little information about how Amazon collects and holds data was explained. Number 4, the time frame, March 20th of 2022. Oh my God. So that'd be like spring break time of Bryan Kohberger not even at the university yet. When the panties were found in the cup holder, that type of shit. Through March 30th of 2022, and then November, I think it was November 1st, yeah. Through December 6th, those were the selected dates that they wanted. Excuse me? Like, what? I think they thought that Bryan was there on spring break. But now, this is the argument, and this goes into case law. And so I can sit here and I can read you all of this part, okay? But I'm going to choose to move forward because what it has to do with third parties. And so here, as this court is no doubt aware, the third party doctrine holds that information shared with anyone with whom a person does not have a recognized evidentiary privilege is free for the government to take without a warrant. Okay. To put it another way, the third party doctrine insists as a matter of law that you should trust your secrets to no one. Okay. And there is a reasonable expectation of privacy. And so Idaho has taken somewhat an unclear approach to the third party doctrine. So in state verse, like I said, like there's just a ton. Mataba, the court permitted protected health records to be provided to the government. In state verse Kloss, the court did the same for billing statements from utility company. In state verse Donato, the court held that people had no expectation of privacy in trash placed out for pickup. However, the court has also held state versus Thompson, which is that under the Idaho Constitution, citizens do have a right to privacy in who they call, and later extended that to text messages. Idaho is not the only jurisdiction to have trouble with the third party doctrine. Okay, the United States Supreme Court has refused to apply it to both it both to the search of cell phones and the use of cell sites. As you can see my little star here, the issues the United States Supreme Court seems to take with the third-party doctrine, okay, in its most recent decisions, seem to be the scope of the information available to the government without a warrant if one follows it closely. And that is in Carpenter. And this is what's cited throughout the whole, all the documents. Carpenter is, and then Riley versus California. So right here, it's the concern was first fully articulated by the Justice Sotomayor in her concurrency in U.S. versus Jones. It is difficult to square this concern with what the court decided in Miller because, as the third-party doctrine defines, Professor Kerr put it, in Miller, the checking account created a substitution effect of replacing a transaction that would have included substantial public components with a transaction that would normally occur entirely in private. So let me go like this. I'll move this down. There it is. Carpenter is the government surveillance case, yes. But to see how, imagine a world without banks. If you need to pay for something in this world, you would need to get the money to do it. You would need to travel to your stash, pick up the money, and then travel to the place where you are making your purchase. If you are the seller, you need to receive the money, take it back to your stash, and store it away for safe keeping. There are public parts of the transaction on both sides. Checks and other credit instruments eliminate the need to travel. So the buyer no longer needs to travel to bring the money to the seller, and the seller no longer needs to travel to put the money away. Instead, the seller deposits the check and the funds from the bank are sent directly to him. The buyer and the seller don't have to move anymore, as the check moves the funds out of and into their accounts without them needing to go anywhere. The third party of the checking account makes the entire economic transaction private. Okay? So this is, in other words, as Professor Kerr argues, Miller makes public precisely the amount of information private. No doubt the fact that our economy has changed greatly since the 1970s has a part to the play in this, but the fact remains that the Miller case and its the Miller case in a way is, hey, what we have to go off of because that's what we have. Okay, the third party of the checking account that's supposed to be private, just like if you were traveling around, nobody would know that. So that's the argument there. Now, what Jay and the rest of these lawyers had to do is they were told to put case law that had to do with showing it working in their favor and also working against them. So I think that these motions were fair with that. I think that it showed that certain cases said this, certain cases said that. But the big things are you can't get around this part, though. Okay. Unless we know how this all went down with the FBI, the IGG, like this is the line of all the issues. So it's not that there's just one issue, guys. There is 3 with 2 subs. Let's see. we're going to get to where, okay, this is, I thought was a really good point. As far as Idaho, it's just easier for me to read like this. As far as Idaho goes, there can be no doubt that Article 1, Section 17 requires a warrant before law enforcement can access Idahoans' online records. Amazon.com, like phone companies, is heavily regulated and guarantees its customers' privacy. See Amazon.com privacy notice. So here's the Amazon.com privacy notice. Then right after it, it says, it is not garbage one leaves on the street where snoops can find it, nor is it HIV information that society has a stake in knowing. And I thought that was an amazing example. Okay, if you have HIV, we have a right to know. Okay, this ain't HIV, baby. And this ain't garbage, you know. We didn't just, my Amazon account is not just left somewhere. So basically why he's saying this is because I don't know if Bryan signed on somewhere and did something in a public location, and then they were able to then get it from that. You know, if his router, because remember, like they all shared some router. But the more I was just thinking of like, what the F, where are they going with this? But at the end of the day, it's I mean, again, they're just going through all of these issues with it. Like there's just not one issue with what they did. There's like a million issues. It's wild. It's wild. The affidavits submitted in support of the application for the issued search warrant recklessly or intentionally omitted material information. I mean, it is for this reason that the courts have insisted that the full facts from which inferences might be drawn and information necessary to determine their reliability be placed before the issuing magistrate. That's not what happened here. Because they don't even know. And this is, you got information from the FBI about what? How? What are you talking about? How are you even writing up this search warrant? Remember, this has to do with the search warrant that was obtained, they said. Going back to right there, Amazon account. There's a federal grand jury, and they used this federal grand jury to be able to get the subpoena. And these were warrants then that Mowry wrote up April 23rd and May 8th. And he's over here saying, I don't even know how some FBI agent said that there'd be this information there or something. Unbelievable. Finally, a criminal defendant may challenge the veracity of an affidavit used to obtain a search warrant. State v. Peterson says that upon a preliminary showing of a warrant's deficiency, the defendant must prove, so this is on the defendant here, the defendant must prove by a preponderance of the evidence, and not by beyond a reasonable doubt, but by the preponderance of the evidence, that intentional or reckless falsehoods were included in the warrant and were material to the magistrate's finding of probable cause, or that the material exculpatory information was deliberately or recklessly omitted. So those are your two windows there, that like either you omitted stuff, okay, or you made false statements. Either one of those, we got a problem. And it has to be material. So we're going to see if they have that. The defense has to show that. An omission of exculpatory fact is material only if there is a substantial probability that had the omitted information been presented, it would have altered the magistrate's determination of the probable cause. Now, remember, all of this is included in this proffer. The proffer required for a Franks hearing is filed, so it's under seal. The proffer asserted applies here, and it's in additional to the proffer, the affidavit for the Amazon search warrants did not explain to the magistrate that federal agents, and guys, this is huge. So this is what we're talking about, like leaving shit out for this. In this, it's like, in addition to what we already have sealed, let's talk about this. In addition to that proffer, the affidavit for the Amazon search warrant did not explain to the magistrate that federal agents had been talking to Amazon. They'd already been talking to Amazon and issuing subpoenas, and that was how they had gathered information for the affidavit. Mowry intentionally failed to disclose the illegal means by which investigators had located the Amazon information. Remember, if you go back now, where Jay says, at some point, an FBI agent subpoenaed Amazon records belonging to Mr. Kohberger's account. Those are these, and then on these days is where we got some information back. But this is when we can't talk about any of this, because that's why would you need to go ahead and subpoena Amazon if you've already got the information? So the FBI already had it, but they realized, fuck, we did it illegally. Because we're over here talking, we're doing X, Y, and Z, right? Illegally. But so here, we will just act like this didn't happen. And you just go ahead and you go get yourself your own, search warrants. Okay. And it gets cleared up here a little bit more when we talk about the affidavit submitted in support of the application for the issued search warrant included information that must be, ixnayed. All information in the affidavit was gathered because of law enforcement's unconstitutional use of investigative genetic genealogy. And so they end with that. Like, these are all the issues that we have. And this is like, you're like, boop. Mr. Kohberger has argued in a separate motion that the genetic genealogy investigation in this matter was done in violation of the Constitution. Additionally, he argues there would be no investigation into him without that original Constitution violation. It is not that the results of the IGG sped up the investigation. Instead, they focused the entire investigation on Mr. Kohberger, a person whose only connection to the case was his mode of transportation and the shape of his eyebrows. Okay? Shape of his eyebrows and mode of transportation. Two identifications of little to no value. As the Idaho Supreme Court has explained, while the initial burden in showing a factual nexus. So here, you can't have it both ways, motherfuckers. I'm going to use that word nexus. Well, here, you fucked Richard Allen with it. All right. Now show me that you have a factual nexus between the illegally or the evidence. Show me there's a nexus, because you're going to have to take all of this shit away. This is what's about to happen. The prosecution is going to have to show how none of this matters, because we still would have got to Bryan Kohberger without it. Like, meaning without the IGG, without the name Bryan Kohberger, show me how you would have got to him again. Because that's what has to happen. So right here is between the state must show it would have been discovered anyway. The state cannot make this showing. Okay? Without IGG, There is no case, motherfuckers. And after I heard everything in Indiana, IGG is the most unreliable shit ever. And we don't even use it. We would never use it. We haven't used it to solve a case ever. This broad was saying like, meh, 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 meh. And I'm just listening in Delphi and I'm just like, wow. Basically everything that's being said in this courtroom is making it no case against Bryan Kohberger in Idaho. And now how we're possibly going to say, oh no, over in Idaho after what they just testified to in Indiana. Come on. Where's the consistency here? What's going on? Like that broad wouldn't even send hairs to go get tested by the FBI. And then once she finally did, then she lied about how many hairs she sent. Okay. And then they didn't even follow up with the hairs. Awesome. You guys are fabulous. You know, it's just a sad world right now. It's just truly a sad world. So again, without IGG, there is no case, no request for his phone records happens, no surveillance of his parents' home, no DNA taken from the garage or the garbage on his driveway, which we're going to get into because it's in a gated community under a garbage collection ordinance, which we've said on this channel from jump. We did a video on it. Because the IGG analysis is the origin of this matter, everything in the affidavit should be ixnayed. Information gathered about Mr. Kohberger via previous invalid warrants must be excised. Bye-bye. And it was, wait till you hear what they say in this next one when they're saying things like this. It's based off of the police officers saying it's their opinion that Bryan Kohberger has bushy eyebrows. They never even did a six-pack with Dylan. Where you didn't even offer Dylan a six-pack to see if she could identify. Like, because Dylan didn't see nobody. Dylan didn't see anybody. Dylan would be dead if she was standing where they're saying she was standing. Why wouldn't he kill her? Why would you ever leave a witness to your fuckerage? That's got to be the stupidest shit I've ever heard. That she was just standing there, frozen. Let it go. And then here, Bryan, because they all would have like literally met face to face. That Bryan was just like, I'm tired. Called the po-po. I'm out. Fuck out of here. Ridiculous. Absolutely ridiculous. You want me to believe that shit? All right. Next up. All right. Bryan Kohberger's apartment. Bryan Kohberger's apartment. Remember, this is part 1 of 2. So this is Bryan Kohberger's apartment. And just like, okay, this is Dawn Daniels getting involved. This is everything that's done over like in WSU. Okay. Apartment. Okay, I got it. Like his apartment. All right. Let's see what's up. His apartment. Well, here comes Bryan Kohberger, Bryan through his attorneys, and we are going to tell you that we need to suppress any evidence that was gathered by law enforcement as a result of the search of his apartment. And these are the issues. Okay. Pretty much the same things. You got the 1, the 2, the 3. And now, but here, let's look at the facts of this. So the fact is that due to the haphazard way in which law enforcement has kept and disclosed records in this matter, the following are the facts. So like, this is all they know is to be factual. This is nuts. Due to the haphazard way in which law enforcement has kept and disclosed records in this matter, the following are the facts. Like, this is all we know, man. All right. Related to the search warrant here at his apartment. On December 28th, Trooper Leary of Pennsylvania State Police became aware of the objective of arresting Mr. Kohberger via Moscow Police Payne. Okay. So then on December 29th at 4:45 p.m. Eastern Standard, this is going to matter, which is 1:45 PDT, a magistrate in Pennsylvania, you guys, issued a search warrant for Mr. Kohberger's person. This is where it's going to get real interesting. On December 29th, then, again, now this is at 2:22, the magistrate in this matter signed an arrest warrant for Mr. Kohberger in Latah County. What? What is going on? Do you guys understand what that means right here off the rip? Do we have an out-of-state, we have an out-of-state warrant for this man, right? So on December 29th at 2:22 p.m., the magistrate in this matter signed an arrest warrant for Bryan Kohberger in Latah County. The affidavit for the warrant was signed by Moscow Police Department Brett Payne. So let's make a note of that. You want to know why they're saying all this stuff, right? Because then they start commingling their affidavits. Commingling. It's like cohabitating, you know. What's mine is yours, what's yours is mine. Whatever you say, I say. So the basic facts Payne used to support the search were as followed. Next to the body of Madison Mogan was a tan leather knife sheath. The Idaho State Lab later located a single source of male DNA on the button snap of the knife sheath. Now, in Indiana, none of this was possible, okay? They didn't locate shit in Indiana. Not one profile came from the crime scene in Indiana, okay? Not one profile in Indiana. Oh, except for a cop and a family member and then an unknown female. Wait, what was that like, Atlanta? Yep. A cop, a family member, and an unknown female. But here in Idaho, this team, these amazing souls in Idaho, they were able to take amazing swabs for skin cells, okay, and swab the button of the sheath versus saying, because you're going to have to make a decision. Are we going to try to lift prints off of it, right? Or is it not a print? Did he just sweat on the button? What are we talking about here? But we got to make a decision. If there was prints, we're going to try to lift the prints. Or if it's prints, do we want to not go for the prints? And do we want to use the swab for the skin cells? That's going to be a decision to be made after you collect the material. So after you process the scene and you have all the shit, then you're in the lab and then you all get around a round table, okay? And you say, okay, should we go prints with this? Should we go swab with this? What should we do? That's what truly happens. You decide how you're going to try to extract this DNA that you believe exists on something. Okay? I'm curious now where they swabbed on the sheath. I'm curious when they found the sheath, but we'll continue. But again, in Indiana, they couldn't get dick off of that crime scene. Number 2, footage from the King Road neighborhood, in quotes, showed what the police suspected was the vehicle of the killer. This white sedan lacked a front license plate. A vehicle specialist decided based on the footage that the vehicle was a 2011 to 2016 Hyundai Elantra, which at first, remember, guys, yes, it was in this category. Remember, I told you guys all about that, though. You would never be a specialist and think that something was a 2011 compared to 2016, just how different those, I talked about that. A vehicle matching that description was spotted via surveillance in Pullman. It was later discovered that Mr. Kohberger drives a 2015 Hyundai Elantra and that he lived not far from the last place. Okay. Right here. He lived not far from the last place. A white sedan was seen driving. Just like, look at this. Mr. Kohberger drives a 2015 and that he lived not far from the last place a white sedan was seen driving in Pullman over an hour later. Like, this is like, when you really break this down, it's like, wow, right? That same specialist indicated the car seen in Pullman was a 2014 and 2016. Now, witness Dylan Mortensen had indicated the height of the person she saw at the time of the attack was between 5'10" and 6 foot. And they had bushy eyebrows. Now, the police determined Mr. Kohberger fit that description. You guys, this is wild. This is unbelievable. You ain't getting probable cause for this shit. There is no way you are going to get anything with this. You're going to look like an absolute fool if you can march your happy ass in there and say, hey, magistrate, give me my shit. You'd be like, excuse me? Wait, what? No wonder why y'all need DNA. Because y'all had nothing, right? And that's where probably Megan is like, I'm definitely going to need some DNA. Get me that DNA and I'll sign your warrant. It's 100% what was said. You guys, what? It wasn't like Bryan Kohberger came forward and said he was at a house party there. Like Richard Allen said, I was at the bridge that day. Okay. All right. I mean, so the girl could give a description of the guy, right, that she saw, right? But she couldn't call 911, right? Solid. And Taylor's going to have a field day with that. You guys do know that, I mean, anybody that thinks that Dylan Morrison is not the state's like main witness or somebody that she has to testify, guys. All right. That's like, there's no ifs, ands, buts about that. Okay, next on. Oh, by the way, records from an August 21st, 2022 traffic stop, by the way, showed Mr. Kohberger was the driver of a white 2015 Hyundai Elantra with Pennsylvania plates, lacking a front plate. It also showed he had the phone number. This. He noted investigators learned this was an AT&T number. How you learned that is interesting. That's why he said he noted investigators in quotes, because it's like, how did you know that Bryan Kohberger's number was an AT&T number? Okay. Mr. Kohberger had changed his vehicle registration to Washington. Like these are all the reasons that you got this probable cause. Okay. Mr. Kohberger changed his vehicle registration to Washington on November 18th due to his birthday. I'm surprised they didn't put that due to his B-Day. And then cell towers, mind you, did not show Mr. Kohberger was in Moscow in the time of the murders. But hey, in law enforcement's experience, however, people committing crimes simply turn off their phones. So guess what? We know he turned off his phone, man. You're going to need a lot more than this. Basically, what they're trying to say is without the IgG, you have shit. You have nothing. This is what you have, right? This is what you have. Oh my God, here we go. Oh. Historical cell location information was obtained and given to a cellular analysis survey team cast with the FBI. The team, interesting. I got to highlight that when it says the team determined. That means nobody has coughed up who the hell did it yet. So that team determined that on November 13, 2022, At approximately 2:42 a.m., Mr. Kohberger's phone was utilizing cellular resources that provided coverage to his apartment in Pullman. They support the idea that he left his apartment and went south. They supported the phone being off. They support at 4:48 a.m. that the phone is south of Moscow, Idaho, near Blaine. The phone utilizes resources that made, their way back to Pullman, coinciding with a white Elantra seen on some surveillance there. A similar data showing occurs at approximately 9 a.m. with a trip into Moscow and returning at, around 9:32 a.m. The same team determined Mr. Kohberger has been to Moscow on at least 12 occasions prior to the event, and that he came into the area that morning following the murders. But however, law enforcement, without explanation, indicated it did not believe that final trip ever occurred. Sorry, but this is absolutely wild. What does this even mean? You guys, you want to talk about conspiracy theorists? You want to talk about being a conspiracy theorist? Listening to this shit, this is a conspiracy to me. Listening to this is a conspiracy. This is a conspiracy to me. You guys. I'm saying, if you were in a classroom right now and I was a student and I'm hearing this, we would have to the assignment would be, what's wrong here? Okay? This is where we get this assignment and say, wow, oh my God, I have to say why this isn't this. And oh my God, why, this is that. Like this, I don't even have anything to say, man. But they're proving here that without this IgG, okay, that somehow miraculously you got off of, you're able to get IgG, but in Indiana, they wouldn't even be able to get a profile. Okay. Nor would it be the first thing that you ever went and did. Okay. You would never go and do this. So why are you go? Like, that is what the woman in Indiana was saying. I would never risk the DNA because you could only use so much of it and then it would be gone. We would never risk it on something that's so low probability, because down the road, we would wait to see if there was better avenues that come out. And so we want to hang on to that DNA. That's what this broad in Indiana is saying. You would never do that because you would want to wait, because the ever-evolving world of DNA, you'd want to wait until you don't want to do that. So I'm listening to this woman in Delphi, and I'm like, oh my God, this woman is saying the complete opposite of what is happening in Idaho. And so I'm trying to focus on the Richard Allen case while I'm hearing this bullshit, knowing that I'm going to get a Frank's the next week. And I'm like, oh my God, this is unbelievable. I can't believe what I'm listening to. It's literally two opposite, everything that they're saying in Idaho is everything opposite that they're saying in Indiana. And I said that to Andrea. I said, wow. I said, wouldn't Ann Taylor love to have a homie here on the stand talking? And she's like, yeah, she would. Then we move on to at 2:43 p.m. on December 29th, a criminal complaint here and probable cause order were filed in this manner. At 10 p.m., which is 7 p.m., Pennsylvania, SWAT began preparations to arrest Mr. Kohberger. Despite days of constant FBI surveillance, despite days of this shit, weeks, Pennsylvania, their own law enforcement, they started doing their own surveilling of him at 11:15 p.m. And despite the fact that the constant FBI surveillance showed Mr. Kohberger was unarmed and he always went on these runs. So he would go for runs around his parents' neighborhood. Police decided, though, that in the dead of the night, it was best within his parents' home was the way to make their arrest, is to just go in there, in the dead of the night and just bang on. And to me, you guys, that's wrong. Okay. Leave his parents out. Leave his mom out. His siblings, if they were there. He went for runs. He went for runs all the time. Why wouldn't you just take him out on one of his runs? It's especially, don't you want to be safe with it? His parents didn't do anything. If he's the one, his family didn't do anything. But let's give people like PTSD for the rest of their lives. Like, that's awesome. And then people are like, who cares? Who cares? He what? He brought on what? His family? Y'all sound fools. But this is what they thought was the best way to go about it. So they said that at 9:25 p.m. on December 29th, the Superior Court judge in Washington issued a warrant for Mr. Kohberger's apartment in Pullman. The warrant was based on the affidavit of Assistant Chief Don Daniels of the WSU Police Department. That affidavit shows that Sergeant Blaker of the Moscow Police Department requested the assistance of the WSU Police Department in investigating this case. That affidavit relied on the same information outlined above. Same information. Remember we were talking about this, how it's just all intertwined, but yet Blaker thinks that Bryan went straight home, but Payne thinks that Bryan drove all over town. Remember, the exhibit is sealed, so on December 30th, 2022 at 1:14 a.m., which is 10:14, back in Idaho, Pennsylvania SWAT and federal agents raided Mr. Kohberger's parents' home. Law enforcement arrested Mr. Kohberger. On December 30th, 2022, Idaho State Police, Moscow Police, and other law enforcement searched Mr. Kohberger's apartment. And the argument is that this court should apply Idaho's exclusionary rule and law to this search. And so when I started reading this, I was like, holy shit, this is wild when you think about it. And this is where I said to myself, well, do I think that they're creative or do I think that they're cheaters? So why I say that is because the first question this court must determine is whether there is a conflict of laws in this matter. Remember, they kept saying this is a complex case? Yeah, this is where it gets complicated. Whether Idaho law or Washington law controls the validity of the search warrant for Mr. Kohberger's apartment and the necessary relief. Unlike the issue of arrest warrants, cases involving multiple state investigations have produced far less case law. In fact, the defense could not find a precise case on point for the state of Idaho. The issue, however, has received some attention in academia. And Professor Kerr argued in his article for the Harvard Law Review that the jurisdiction where the crime occurred should control how the investigation is done, but that states and or the federal government should provide some form of authorization to each other to participate in each other's criminal investigations. As it stands, there are at least 5 different approaches to this increasingly common situation. Now, I want to point out that the affidavit relied on the same information outlined above. The reason that they had this little footmark here with the one there, that footnote, is you guys remember that the only thing that kind of differed that was big with the Don Daniels search warrant is that Don Daniels wanted to tell she told the magistrate, hey, please do not rely on what? So there was a supplemental section to the affidavit indicating DNA on the father of the person whose DNA was on the sheath had been found in the trash at Mr. Kohberger's parents' home. However, the Superior Court judge specifically did not rely on that information in determining probable cause. In this matter here, Idaho authorities requested assistance. Now everybody can know here that Idaho requested assistance from the FBI and WSU police. They requested the assistance. Thus, this court should be required, to apply Idaho's search and seizure laws to their actions in Washington, is the argument. But either way, it doesn't matter. Because again, I think Jay's just covering all bases here. Another key point out here is that given all of the circumstances set forth in the affidavit, there is a fair probability that contraband or evidence of a crime will be found in a particular place. Remember we were talking about this? That the affidavit submitted in support of the application for the issued search warrant recklessly or intentionally omitted material information. And it's like, well, did Bryan Kohberger go driving around in circles, remember? Or did he go straight home? Because why do you think that? And why do you think that? And why are you getting to pick and choose how you want to have your ending here? Like, it's just wild to me. Again, making note of it that, hey, you can find all of the stuff that we're arguing and all the facts that we're laying out. It's in that Franks, which is sealed here. So, again, it's all that Mr. Kohberger is saying, that the IGG, everything stems from that. At the end, like, that's the final argument with everything. You have the Apple account, again, federal search warrant dated August 1st, 2023. This is the last one I'm going to do, and then I'll be going on to part 2 later. But here, the issues with the Apple is interesting because there's more issues. Okay. So before we just had 1, 2, and 3. This here we have 1, 2, then we have A, B, C off of 2. We have 3, and then we have 4. So the issues here that are added is that information gathered about Mr. Kohberger via previous invalid warrants must, they're saying they must be ixnayed as well. The search warrants failed to command law enforcement to search the Apple accounts or contents of the iCloud. Now, this is what I thought was just like, wow, are you that dumb? That they didn't ask in these search warrants, they failed to command, like, all you were basically asked for was to basically seize the shit, not search the shit. Okay? Like, how can you be this? How does this happen? Okay, the search warrants failed to command law enforcement to search the Apple accounts or contents of the iCloud. And then I'm like, but we're going to find out why. And it's because they were doing all this bullshit around it and cut, copy, paste type shit. The search warrant failed to provide specific particularization of what to search as well. And so the facts is that on remember, this is the Apple shit. This is on December 21st, 2022, the FBI issued a preservation request letter to Apple. A preservation request. On December 30th, the same day that he was arrested, Pennsylvania law enforcement, along with officers from Idaho and the FBI, raided Mr. Kohberger's parents' home. So all it was a preservation request. So the FBI issued a preservation request letter to Apple. Okay. So these are the facts surrounding the Apple. And then on December 30th, 2022, Pennsylvania law enforcement, along with officers from Idaho and the FBI, raided Mr. Kohberger's parents' home at 119. And they arrested him. An iPad was located at the parents' home, but it was not seized because it was found in a common area. During a subsequent search of Mr. Kohberger's vehicle, okay, a receipt was located for an Apple iPad. Based on incomplete records available to the defense, FBI served a grand jury subpoena on Apple on January 12th, 2023. Remember when we had a hearing and Mathis is talking about, we understand that the people can use tactics such as, conducting an FBI federal grand jury as a way to get information and then turn it over for, we're well aware of the tactics that can be used. Okay? We're well aware. So they used and had a federal grand jury to be able to get these subpoenas, right? And get this information to then turn it over for the Moscow Police Department to be able to use in their case. So an iPad was located at the parents' home, but it was not seized because it was found in a common area, which was not part of the deal. But during a subsequent search of Mr. Kohberger's vehicle, a receipt was located for an Apple iPad. Based on incomplete records available to the defense, FBI served a grand jury subpoena on Apple on January 12, 2023, and Apple produced responsive data on January 27, 2023 for Apple accounts, DSID and then a number, DSID and then a number. Those are in Exhibit B. The data was shared with Brett Payne of the Moscow Police Department. Subsequently, after that, Apple sent an email to FBI Tactical Specialist Maria Tinald acknowledging receipt of a preservation request on April 6, 2023. That's Exhibit C. Over the next few days, Detective Mowry, always getting himself in the fucking mix, because I told you guys he was used as the oh, Mr. Mowry, we need you to go and do this. Okay, what can I do for you guys? God bless it. If I was him, I'd be one pissed bastard. I'd be so pissed using me like this. He's like, I better get a raise and I better get this. I better get promoted. So over the next few days, Detective Mowry of the Moscow Police Department was included. Was included in an email chain discussing Apple's response to the preservation request. Like, this is our way of saying, hey, go get this. He was included in an email chain. Okay. The communication references setting up a chat with Apple, with Apple's point of contact to discuss issues that need clarified to resolve. It's like, wait, what are you guys doing? We're in a chat, with the FBI. Here, we're just going to put you in it now. And so the communication also include Apple telling law enforcement which accounts do or don't exist for Mr. Kohberger. You guys, how does that happen? And then here it is again, the famous words. Perhaps recognizing that subpoenaing Mr. Kohberger's records was a violation of the United States and Idaho constitutions on August 1st, 2023, Corporal Payne of the Moscow Police Department requested a warrant for the same information subpoenaed from Apple by the FBI. So they did it again. They were trying to bury what the fuck they did with the FBI. They already had all this shit through the FBI. The FBI is on the case. What's the problem? Oh, the FBI obtained it all illegally, right? So now we have to have good old, here it is, Detective Mowry. Now we have Payne coming up here. And Payne is like, okay, well, I'll just request a warrant for the same information subpoenaed from Apple by the FBI. Admitting in his affidavit, like, what a dipshit. I love fucking ignorant assholes. I love this. Then Payne just admitting in his affidavit at the FBI. What a dipshit. Already subpoenaed the requested information. This is why they want this. Wait, you already subpoenaed this? Well, what did you use to get the information? This is why we have a right to this shit. Already subpoenaed the requested information. And then here's the FBI, like, God, these dumb assholes. They don't even know. Well, yeah, when you give it to... So Corporal Payne served the subpoena. Okay. He served it later that day via email. And then, hey, on August 7th, Apple sent an email to Payne responding to the warrant and providing access to the responsive data. No wonder why it was available the next day, because they already had it. You guys see that? These requests, okay, they came back so fast. I was like, damn. Well, now I know why. Because these people were like, we already served this, so we're just gonna give you, because no wonder why all these records, you guys, they already existed. That's why all these subpoenas were like, here we go, we served them, we got the information back like this. Why? Because these companies already did the work, and they're just filing, they're just literally pushing forward a file that they already created. And now, so when you go back and look at these, when you go back and look at these search warrants and the dates that they were served and how quickly this information came back, then now you can tell, what stuff the FBI already asked for. And that's why they were able to get this stuff so quickly. It's all right there. And I think that TNT had a lot to do with helping out. We caught that shit. Whatever. I mean, this is absolutely sickening. This is disgusting. Okay, this is not how, this isn't how you, you know what sucks is that if Bryan Kohberger did this and he walks because of this fuckerage, now that's a sin. And all those people, that's disgusting. But hey, what are we going to do, right? Unreal. Unbelievable. Here's Payne. Well, I got myself. Apple sent an email to Payne, to Payne's request. Here you go. Then on August 9th, Payne and Detective Mowry downloaded the data provided by Apple in response to the search warrant. The data was inventoried and a return of search warrant was prepared. Again, this is all stuff that's in the sealed shit. The August 1st, 2023 affidavit for search warrant, remember, because the FBI already did it, but here Payne's like, I'm going to serve this up. It was signed by Payne, and it's Exhibit D. However, most of the information that Payne signed, most of the information in the warrant was cut and pasted. Cut and pasted from an affidavit originally bearing the signature of Moscow Police Department Sergeant Blaker. Do you guys understand this? but according to Payne, was now his sworn affidavit. You guys, this is bad. This is so bad. How do these people have jobs? You know, this is what happens when you have a lot of yes men in the same room. No brain cells? Yeah. So the basic facts Payne used to support the search beyond those included in the affidavit were, so whatever was in what we already see, his knowledge of Apple and what data it maintains with an Apple ID. Because, he has all this personal knowledge because he works for Apple. You guys didn't know that? So his knowledge of Apple and what data it maintains with an Apple ID. The method that iCloud uses to, quote unquote, create, store, access, share, and synchronize data, internet connection devices, and including the backup device data. Number 3, on January 7, 2023, Apple had responded to the federal grand jury subpoena. Like, look at him writing and just outing it. Oh, Payne. I don't think you're supposed to say all that, but okay. Thank you. On January 7th, the Apple team had responded to the federal grand jury subpoena that a quote-unquote full iCloud account under the name Bryan Kohberger was in active status. And another account, Wi-Fi Army owns at Yahoo, without a doubt, com. That was inactive, though. Using the information produced in the federal grand jury subpoena, Corporal Payne determined that the AMS subscriber _ account was linked to Bryan or B. Kohberger. This is a new one. B. Kohberger at Spartan. So basically, he's admitting that he used an illegal search warrant here to then get this. Okay. We don't know if, he's mentioning it here. Like, do you guys see this? Is like, dude, you're blowing up your own spot. They're blowing up their cheating ways. Or, like I said, is it creative? And then, if it was so creative, you should just be able to do it. But here's Payne. And now, can you imagine if you're a defense attorney? Think about this. You had a defense attorney. And they don't open up any of this stuff. They don't look at any of these pages. You know how many defense attorneys don't open up discovery? A lot. They try to get their clients to take a plea deal. They're not going to do all this work. That's why they're public defenders, though. Let's not forget. They're lazy. Lazy. The worst attorney is a lazy attorney. Always remember that. People that are just so worried about billing you for your time to open up an email, run. Now, what else we got here? Timing of account access as searched by Payne was around December 20th. Oh, wow. So timing of account access as searched by Payne was around December 20th. You guys know what was going on right before that, right? The AT&T records, right? This is crazy. I mean, they're just laying out just what they did. When Payne knew Kohberger was in Pennsylvania, still accessing the Apple account with a known iCloud before the homicides and then days before his arrest. Corporal Payne requested a very broad time frame of October 7th of 2016. Oh my God. What do you need in 2016? I'm just curious. How? To December 30th, 2022. And for any and all Apple accounts linked. Argument here. Mr. Kohberger has privacy interest in his Apple account information protected by the Fourth Amendment of the United States Constitution in Article 1, Section 17 of the Idaho Constitution. So, requiring a warrant. It is requiring a warrant if you want it. This is why this is important. Not, not just any warrant, but a legally obtained warrant. This is right here. Or I'm going to stop right here. Basically, what they did was a cell phone search. Okay. In this matter, Corporal Payne specified in his request that the purpose for gathering the information from the Apple Inc. folks was a belief that the Apple accounts would provide information concerning Kohberger's plans, thought process, research, locations, photos, or other pertinent information stored on his Apple account, including his iCloud account. In 2016, 8 years earlier, okay? So pursuant to Carpenter, remember, to the extent that the information gathered included information from an Apple account created in 2016 and an iPad purchased in 2018, such information included device backups, private emails, documents, photos, and videos that predated the applicable time frame that Mr. Kohberger was in the Moscow-Pullman area. Mr. Kohberger has a privacy right pursuant to both the Fourth Amendment and the Article 1, Section 17. This was, in a sense, a cell phone search. Okay. Therefore, to collect the records law enforcement requested from Apple, it had to have a valid warrant. And that valid warrant could not rely on records produced by a federal grand jury subpoena or a search warrant that recklessly and intentionally omitted material facts. Boom. Mic drop. Like, basically, Hippler doesn't even have, like, do you think Hippler wants to be involved in this fuckerage? Absolutely not. He doesn't want to be involved in this fuckerage. So when I see these comments in the comment section of people's channels, and they're like, of course his defense team is going to do that shit. Who do they think they are? They really think that they're going to suppress evidence that shows that he's guilty? We have actually no idea what's in what they're asking to be suppressed. They're going off of our rights, you morons. Our rights. Think about when your kid's at school, okay, and a teacher says something or a principal says something that your kid did, okay, and it involved another kid. All right, well, wait a second. How, you're saying X, Y, and Z. Well, how do you know that? Was it on record? You're just going to take their word for it? I'm going to ask a lot of questions before you start labeling my kid a problem child, right? Because we know how that goes, right? All these people commenting on shit. You know what I noticed about mainstream media? That with this, they're having 1 to 2 minute blurbs saying, Bryan Kohberger's defense team files for Frank's hearing. Bryan Kohberger's defense team is asking for stuff to be suppressed. Period. End of story. And they're ending their, like, that's all it is. They don't want to talk about all this. They don't want to talk about all this. Mainstream media, they don't care about our rights. Or they're like, God, I wish I could say a lot more, but I get paid by this company, and I'm going to lose my job if I try to say something that's just not by the script. And that's why I love what I do. And I would never go and do anything that made me go against, like, who I am as a human. Excited, how are ya? Good to see you in here. So I'm going to close out here with, because remember, there's going to be a 2-part. It's just, you guys, this is wild. What they're alleging, and I mean, they have all these exhibits. They're showing all this stuff. I don't think they're lying Why would they lie? I know I wouldn't lie for Bryan Kohberger. Why would they lie for Bryan Kohberger? I'm not going to lie for him. Who's going to lie for him? Most hated man in America, you're going to go lie for. Out of here. You just don't do those things. Sherry! Preemie, baby! Time flies and we're having fun, Truth Seeker. Remember for 19 months, baby. Kate, thank you, Lana. Love everyone here. I know, isn't everyone sweet? Oh, just trying to help Lana meet her goal. Cowbells, hit the thumbs, people. Oh, Sherry, shake it. Crime Star. Oh, thank you. 222. I love all those weird numbers. The best way to support Lana is leaving that touch DNA. Yeah, leave that touch DNA. Be careful what you touch. Wipe it all down. Moonvale gifted 1, 2, 3, 4, 5, 10 total. Heck yeah, 10 people turned green. You truly do the Lord's work. Oh, thank you. God bless you too. You know, this isn't, I don't care if it was John Smith that was whoever. This is not okay, guys. This is just not okay. Reading this stuff. Thank you. Okay, Granny. Appreciate you. Yeah. Please keep going. All right, I'll finish this one out. You know, this is just gonna suck. This totally sucks for the family. You know, to see all this stuff done, and it's just like you jeopardized my kid's case, and you did all this crap like this, and they're over there saying, like, are they lying to the family and saying no? You know, they're just gonna have to say all that stuff, and this is just customary, and there's always suppression hearings, and it's just, you know, this is, what are you talking about? If you think that this happens, you guys, in cases every day, Sheldon Jeter Jr. would kill for something like this to have been done for him. Because this type of stuff happened to him. Lying and saying what time you went and got a surveillance camera from a very important store. Acting like you got it the night of and that you watched it. And that's why when you went to the house, you saw, oh, wait, that's the SUV that we saw on camera. So that gave us probable cause to do X, Y, and Z when they hadn't even gone into that convenience store to get that surveillance camera. How do I know that? Well, because all of their guys were inside the crime scene tape. Still at the crime scene. They didn't go and get this. It was closed. The store was closed. There's no report of it. Okay. They didn't bring in the store owner to say, hey, did you give them the tape? That's what you call, like, Sheldon get a Franks. That's what happened. They lied. And then it's like, well, Lana, how did they know that would be on the camera? Because they were watching him. Because they were following him. And they waited till he came past a certain point, knew that he would pass over those cameras, and then put the body right behind him. It's disgusting. That's how they framed that young man. And I can prove it. We're waiting for him to get that new trial based off of this new evidence. But his lawyers didn't do it. This doesn't happen every day. This isn't lies. But if I was the parents, I'd be so pissed. And I'd be placing my pissedness right here off the people that thought that, you know, why was Payne in charge of this? A 2-year person who's never even, I don't even know, he goes and does tickets for noise complaints. That's what he does. So why are you putting a 2-year police officer on a quad homicide? That just blows my mind. Well, because he's going to be a yes man. Because he's a yes man. And I have no idea if this Franks means that, and all this suppression means that he didn't do it. What it just means, you don't look past the point of what this is all about, which is, are we supposed to do this? Is this supposed to go on? We have rights for a reason. We don't get to pick and choose when our rights are allowed to be violated. But he did something so heinous. We don't know that. And if you're going to do all of this, you guys, how do we know? Then you have to look at the sheath. And was that planted? This is what would tell me that it would be. And if it wasn't, then shame on you people. But this is what would give you every reason to think that it would be planted. Because of this, because of the way that you guys are running and doing your shit. But then here we are just asking juries to keep just bailing shitty ass employees who happen to be police officers out. Stop doing it. Stop allowing our rights to be violated. We, the people, are the jurors. Okay? When do you start considering having a bench trial, man? I need the sheath on body cam. Yeah, they talk about body cam too. You know, there's so many more booms in here. I think the biggest boom for me is when I see this at the end. Okay, and Jay wanted to make a good point, and so maybe this is what I'll end on. Is, you know, there was talks about that Bryan Kohberger said, who else was arrested when he was arrested? That stupid saying. Okay. And here Jay makes a point to say, you know, he says, in determining whether a person has been subjected to a custodial interrogation for purposes of Miranda, courts may also consider the conduct of the officers and the nature and manner of questioning. So the conduct of the law enforcement with Mr. Kohberger in the house is referred to as a small talk when he is being recorded during transport. That was considered small talk. This cannot be verified, though, because no audio or video is produced. Okay. The conduct of the officer in the police car during transport cannot be described as an interrogation. However, without a video or audio recording of in custody discussions inside the house, because remember, I told you guys, PSP does not have body cams. I knew that from the Sheldon Jr. case. They're not going to be wearing no body cams. They don't have body cams. I don't even know if they have body cams. Okay. But guess what? It says that, so there were no body cams. So the discussions inside the house, so he says the true nature of the statements made in the car are without context. All statements made, okay, at the police station were post Miranda. Information in the media right after arrest and attributed to law enforcement. Remember, Brian Etten said it was a law enforcement officer that was attributed to law enforcement. There was a report that Mr. Kohberger, remember, he said, who else have you arrested? Remember that? Such a statement is not in a police report or in an audio video recording that can be found in discovery. If it is a statement that the state will seek to attribute to him at trial, it should be suppressed as a non-Mirandized statement. If the conversation with Mr. Kohberger inside the house was a custodial in nature, that context may warrant suppression of the conversation in the police car during transport. You guys, this is found nowhere in any police reports that this ever happened. And yet, what does mainstream media do? They don't vet it. And they just put it out there. And it hasn't been retracted. And that literally came out and went, it was wildfire. And that's bullshit. And that's why I posted and said, take back your shit or cough up your source. You want integrity? You want me to say that you have integrity? Take it back or cough up the source. Because your shit just got blown up. And anybody that doesn't have a problem with this, I have a problem with. And don't watch my shit. Because this shit's disgusting. You guys, those people are getting paid. Paid. They have a job that pays them and they stick to scripts. And who do you think pays for commercials? This is absolutely heinous and disgusting, Joanne says. This type of stuff this isn't about somebody being innocent or guilty, you guys. I don't know if Bryan Kohberger is innocent or guilty. I don't know. None of us know. But this isn't okay. This is all I'm talking about. This type of shit. And all I ever asked for is, how'd you get to Bryan Kohberger? How did you do it? How did you do it and not violate our rights? I want the right person. And we want to make sure this stuff doesn't happen, right? We don't want this to happen to anybody else's kids. Just like you don't put people in cages and treat them like wild animals. Animals are treated better than the way that Richard Allen was treated, but you don't need to touch anybody. You don't need to house anybody differently. If that's what you have to do, if you have to violate people's rights to get confessions, A, you suck at your job. B, like, you're violating our rights, right? But how damn dare you think that you could do that and that you're going to be supported by, because everybody has higher ups. So it's just not even the person that's doing it, but then it's being either buried or supported by higher ups. And so it's like, this is just wild to me. Like, we do understand that Bill Thompson has to make the decision if you're going to go forward and prosecute, right? What are you saying now, Billy? You didn't know any of this happened, Billy? What are you doing? Just strumming your guitar? You didn't know any of this? You didn't know that they did all of this type of stuff? You didn't know about any of this shit? And then all the Franks and you didn't know that any of this stuff happened? Oh, I know that you did, because you said you'd send your kid to school on November 18th. You said that you'd send your kid to school because you said, well, I know a lot more than everybody else, I guess. You should be a damn witness in this case. And if I was Ann Taylor, I'd slap you with a fucking subpoena. Ann Taylor knows exactly what she's doing. And you knew exactly what everybody did. And now Billy's going to wonder, is the FBI going to bail him out? Okay. Or is or is this freaking whole case about to flop? And we'll get that answer in January. But this shit, I've seen enough of people, maybe Bryan Kohberger is the person. Okay. But guess what? I've witnessed personally people that aren't the person. And this is the type of shit I've seen. What I see in here is what happened to those people. And nobody did anything about it. And when there's no consequences for shit like this, then everyone's just going to do whatever they want to do. And we, the people, have the last layer of defense. You hear about this stuff when you're a juror, it's an automatic not guilty by reasonable doubt. You just provided reasonable doubt for your whole entire case because I don't trust you. And that's all you have to say to yourself. So I want to start having standouts like they do for Karen Reed, like free Karen Reed. No, we need to have standouts for citizens because one day you're going to be a juror. Maybe you won't, maybe you will, but there's a day that could come that you could be a juror. Stop letting this shit happen. So, hey, judges don't want to help out. That's fine. We the people are the last line of defense. We're the jurors. We can say, guess what? You didn't prevent it. We are. We are. This shit would never fly if I was in a jury room. And for anybody that says that they're going to stand there and be like, okay, guys, so the police made mistakes, but we cannot not find him guilty because the police made mistakes. No, the police violated our rights, not his rights, our rights. And until we make a stand, then the police are going to continue to violate our rights. Just like the prosecutor. They were hoping that there was just going to be a plea deal here. Bryan Kohberger's going to take a plea deal. Give him a plea deal. Take the death penalty off the table. Nobody cares until it happens to them. Until it's their kid or their grandkid or themselves. And it's like, how do you even... I don't understand that thought process. You don't believe that people lie? You don't think the police officers lie? You don't think that people could make mistakes and then instead of just saying that they made a mistake, cover up their mistake? And then you just get into a crazy path. You don't think that lawyers lie? You don't think that doctors lie? You don't think that humans lie? What world are you living in? What world are you living in? Happens every day. Happens multiple times a day. Nobody files this and has to steal a bunch of shit and the state stipulates to it when there ain't nothing to be seen. Nothing to see here. But we'll come back with part 2 tomorrow night. Join me for my Sunday night show. Thank you guys so much. You guys rock. We're the last layer of defense, man. Okay. Last layer of defense. The jurors. And right now, I saw the Delphi case. I saw the Karen Reed case. And it's like, if you can't get reasonable doubt out of those 2 cases, what case can you? Like, what case can you? And I think that both of those 2 people are factually innocent. I had the pleasure of streaming the whole entire Karen Reed case. Did the timeline myself, put it out there. It is factually, I believe, impossible that Karen Reed hit that man without everybody seeing him on the lawn. And then she had to get back on the Wi-Fi. There was no motive there, whatever. I don't think that his wounds were consistent with that. But there's no way that I could ever say that the state proved their case beyond a reasonable doubt at all. And if you wanted to get Karen Reed for drinking and driving, well, then you should have done that when Karen Reed was drinking and driving. I'm not going to find Karen Reed guilty of drinking and driving. Absolutely not. I have no idea if she would or wouldn't pass. I have no idea if those shots or those drinks, I know how bartenders are. They're chintzy when they pour, you know. I didn't see a smashed Karen Reed on any camera. And I didn't see any video surveillance of Karen Reed being, swerving all over the roads. So no to all of it. Look at the Delphi case, and I just think, oh my God, We don't even know what time that the crime happened. Just it's wild. And then I just go back to this case, and I'm like, I've been saying it since day one. How did you get to Bryan Kohberger? And now I know how you got to Bryan Kohberger. And you violated not only his rights, but I think our rights in a ton of things. And things were planted possibly. Nobody has to do all of this. Nobody has to do all of this. And their motive is that he wanted to become a serial killer. So he thought his first job would be to go kill 4 people. And that he would circle around the crime scene 4 times before he was going to go up in that crime scene. And make it a crime scene, rather. I'm going to try to get seen on every camera possible. That's absolutely fucking crazy. And he's a PhD student. And you think that that's what was... Okay. Sounds good. Sounds good. You know, God forbid we look at the university. God forbid we look at the sororities. And God forbid we look at the fraternities where all the money comes from that pumps that town. We can't have it go back to anybody that would be involved with the money. Because that town is non-existent without the sororities, fraternities, and the university. They said, here's your name, work backwards. We can't give you the real reasons how we caught him. But here you go and make it fit. All right, sounds good. And that's exactly what they did. And they got caught. And then they got caught. And so what's going to happen? What's going to happen now that they got caught? Anne and her team caught them doing what they did. Now you're going to have you disaffected families. That if this man did this, that this man's going to be let go and it's going to be a danger to society, right? Because you guys violate rights. This is just horrible. Absolutely horrible. But Ann Taylor's team caught them. Hands all up in the cookie jar. Caught them. And you're going to sit here and tell me that Judge Hippler is going to see all this and look the other way? And look the other way? I would never clean up anybody's mess. I'm not going to clean up your shit. And so Hippler, if you are who you say you are, you're not going to clean up their fucking messes. I'd admonish the fuck out of them. I don't know how people don't get pissed when, like, if I was a cop and I saw these cops did that and treated my profession like that, I'm not going to back them. I'm not backing this. Get out. You're giving us a bad name who do an amazing job every single day. Just like teachers. I'm not going to, just because there's a union, I'm not going to back you because you're diddling a 14-year-old. I'm not backing you if I'm a teacher. You know, get the hell out of here. Ridiculous. Peace out, guys. We'll be back with part 2 soon. Tomorrow night. This November 29th. 4 people that were murdered, and you want to fuck around. I knew about it.
We're not here to talk about the alcohol stuff, okay?
Okay, yeah.
But this is the second noise complaint we've had here tonight within 2 hours.
How are you?
Good, how are you?
Good. Is this your place?
Yeah.
Perfect. You know why we're here?
And I see noise.
Noise, yeah.
Yeah.
Big speaker right there.
Yeah.
Nothing against having a party. Once neighbors start calling in, then we have an issue.
Like brains and like if you